Christy. Okay, our next speaker, we'd like to welcome Yvonne O'Krant. Yvonne practices in the areas of equine law, title insurance, employment law, and commercial litigation. She is a trial lawyer and mediator. Yvonne's equine law experience includes handling litigation involving the Equine Activity Liability Act and various other state and federal laws. She assists individual horse owners, trainers, breeders, riding, boarding, and training facilities, veterinarians, and other entities in the equine industry to litigate and resolve claims for personal injury, property damage, breach of contract, fraud, misrepresentation, and other legal issues. She drafts contracts for horse purchases and sales, leases, and commission arrangements, and creates equine liability releases for boarding and training facilities, trainers, transporters, and other individuals and entities sponsoring or participating equine activities. Please welcome Yvonne O'Krant.
If that doesn't get to the edge of your seat, I don't know what will. That was pretty exciting. Thank you. I'm going to speak loudly as well. I appreciate Christy for making that possible. If anybody in the cheap seats can't hear me, let me know. But I'm from Chicago. I talk fast. I talk loud. The judges like it, but the audience doesn't always. So just stop at any time and let me know. I am going to try and get through this quickly. If anybody does want to get a snack or some pop, feel free to do that. If you stay awake till the end, I will be offering free consultations. But only if you stay awake. If I see those cowboy hats tipping up and down, you're out. So, I am an attorney from Chicago. I work in a large law firm. We have 550 lawyers. We have 25 offices nationwide, and I am the only equine attorney there. I started this practice within my firm about 15 years ago, realizing that if you want to make partner in a large law firm, you better come with your own book of business. So I started to figure out what can I add value to this firm that is different from what anybody else is doing, and I was already an equestrian. I'm a 3-day event rider. I know you think we're all crazy, but you can be a lawyer and a 3-day event rider at the same time. Sounds like drinking and driving. But I know what I don't know, and I know what I need to do to protect myself from liability, and you're all going to know that before you leave here today. As a lawyer, I'm going to use a lot of scare tactics. I'm going to make you afraid. I'm going to sell you tennis rackets in the hallway because you don't want to give up this wonderful sport of horses. But I'm also going to tell you that there are ways you can protect yourself from the risk that you're going to appreciate when you leave here. Feel free to ask me any questions afterwards because we are running short on time. I will stay as long as you need me to. I scheduled a late flight so I can be here. I will provide you with my time today. I am here for you free of charge. Yeah, of course. Oh, great. And no other lawyer will tell you it's free of charge. Because there is no such thing. But I'm going to tell you that that isn't that case. I'm told I need to use the microphone because of the recording device. So if I tend to get away from the microphone, let me know back there. So what I want to basically introduce today is what is equine law. Like I mentioned, I have 550 partners in my firm, and 549 of them have said, what the hell are you doing? You're playing with horses, isn't that nice? And by the way, I spend my winters in Ocala, Florida. So they really were not convinced in the beginning that this was a legitimate practice. And what I'm here to tell you is equine law is every area of law that you have ever heard of, experienced, seen. It just involves horses, right? We have contracts in horses. Believe it or not, people are actually using written contracts now in horses. If you're over the age of 50, you might not believe me. But it is true. This is a new normal. We are using contracts, and before you leave here today, you'll know how they actually can be worth more than the paper they're written on. Personal injury, people get hurt. Property damage, believe it or not, while I love horses as you do, they are still considered property under the law. So when horses are injured, property law issues. Insurance coverage. Intellectual property, the Twin Spires at Churchill Down, there's litigation on the copyright protections and trademark protections. That's your intellectual property law. And lien enforcement. Anyone here ever provided services and not been paid? Probably nobody. But if you have had that experience or heard of it, there are lien laws in place that can get you paid if you have not been paid for services provided. So that's in a nutshell what equine law really is. What I want to focus in on today is one aspect of equine law, which is equine liability. A lot of you have probably seen those aesthetically pleasing black and white letter warning signs up at facilities, and you think, well, there must be a lawyer involved that we had to do this. It's always the lawyer's fault, according to my father. But the reality is that the reason those signs are posted is because there are state statutes that require it. Why do you care? Because if you don't post the required sign, all those liability protections that you think you have are taken away from you. And you'll know that, you'll understand that a little bit better when we get through a few of these slides. But that's one example of how knowing what your state statute is on equine law is so important. 47 states today have their own state-specific equine activity liability statute. Nevada is actually the most recently added state to this list. It was 46 before I did this presentation today. The reason the statutes were enacted was because the General Assembly in each state recognized that there is both an inherent danger as well as economic benefit. Now, I'm an amateur rider, so I don't see any economic benefit personally, and I hope the rest of you do. But the states recognize that there's a financial benefit to equine activities. So how do we encourage professionals like you to continue to provide these equine activities where they are inherently dangerous? Well, one of the answers was to shift the responsibility from the provider onto the participant. Now, you're probably all looking at me and saying, well, Yvonne, I thought it was assumption of risk. I thought anybody who was on or around horses assumes the risk of getting hurt. Well, then why am I so busy in litigating cases? Because it's not a true, pure, zero liability law. There are liabilities in place, and you're going to know what those are. But the point is that the state realizes that there still are liabilities, there still are risks for you, and so we need to find a way to shift that burden away from you and back onto the participants so you keep doing what you do. What do these statutes say? Now, I'm not here to put you to sleep, but if you can't sleep tonight, you can take a look at what the statutes say, but I'm going to give you the quick Cliff Notes version. The statutes provide the definitions of what is an equine activity, who is a participant in an equine activity. Why do you care? You're going to know in a couple slides that if the person that was injured was not participating in an equine activity when they were injured, you have no liability protection. Now you might sit here and say, well, aren't we talking about horseback riding? Aren't we talking about somebody getting injured on a horse? Isn't that clearly an equine activity? Isn't that clearly a participant engaged in an equine activity? Well, sure, when it comes to riding. But let me ask you this, and anyone who's seen this presentation before, hands down. Who here thinks that leading a horse into a horse trailer is an equine activity? You should think it's a trick question because lawyers can't be trusted. Leading a horse into a horse trailer is only an equine activity if your state statute says that it is. Let me tell you, my recollection is there is not one state statute in those 47 states that has leading a horse as an equine activity. So what does that mean? In a case I had in Indiana, my client had a horse being led into a horse trailer. The mare had a fall at her side. The foal took off, and obviously the mare got upset. The mare reared up, kicked the handler in the face, catastrophic facial injuries. And my client came to me, and I took photographs, and I took depositions to determine, was this person engaged in equine activity when they were injured? The state statute did not provide leading a horse into a horse trailer was an equine activity. So my client did not have liability protections provided by the statute. The caveat to that was they had a boarding agreement, and this is why you're going to use boarding agreements when you leave. The boarding agreement did provide that leading a horse into the horse trailer was one of the services that my client was providing as a boarding activity. Boarding horses is an equine activity under the liability statute. So fortunately for me, the judge and my opposing counsel had no idea what I was talking about, and I convinced both of them that this was a service provided under the boarding of equines. And since boarding of equines is an equine activity under the statute, the case was thrown out. Now, I'm going to tell you that's a My Cousin Vinny example, which I was very lucky to have won. It was scripted by a director. I would never risk that again, but I'm here to tell you that not every interaction with a horse is an equine activity. Each state statute will tell us What is an equine activity under the statute so that we have liability protection for that activity? The statute provides that it's a participant's responsibility to act, act in an appropriate manner given their skills and ability, blah, blah, blah. What are we more concerned about? I just told you that if you have a participant engaged in an equine activity and you posted your warning sign, you've done everything right. How is it that you still have liability? Because each state statute, like the government is good to do, is to giveth and taketh away. They have exceptions to the liability protections that are given to us. And I'm going to tell you what those exceptions are before you leave. But the point is that each state has their own exceptions, which means you do everything right. You may still have to call me. Okay. Warning sign postings required by the statute. We mentioned that. Contracts. If you are using liability releases, which you will be before you leave today, your boarding contracts, your training agreements have to have warning language if it's required by your state statute. Why do you care? You can have a 12-page liability release in 10-point font, double-sided. But if your state statute requires that same warning language from the sign be in the contract and you don't have it, no liability protection for that contract. Okay? I know, kind of scary stuff, isn't it? Not anymore, because you know it. That's all you need to do, right? To know it. That's what Christy said. All right, what's an equine activity? Illinois and Wisconsin is one example of where it's important to know the differences between what your state statute provides. Here's just a quick example, because I don't want to keep you longer than you need to be here. Driving a horse-drawn carriage in downtown Chicago is an equine activity. I'm sorry, it's not an equine activity under the liability statute. Driving a horse-drawn carriage in Wisconsin, right across the border, is an equine activity. So what does that mean? If you are driving a Hansom cab in downtown Chicago and one of your passengers is about to fall off, get your ass into Wisconsin before they hit the ground, so they are engaged in an equine activity. It's very simple, people. Gotta be an equine activity in your state. Who's an equine activity professional or sponsor? The statute's going to tell you. What are the risks of engaging in an equine activity? All of us in this room, I guarantee you we could come up with examples that are not in the statute. It is not an inherent risk unless the statute says so. What the statute does really well is it is somewhat broad. It will say, a horse's unpredictable reaction to unfamiliar sights, sounds, and noises. Makes sense to us, right? Who here thinks that a judge in a black robe sitting on his podium knows the difference between what is an unfamiliar sight, sound, or noise to a horse versus a dog versus his daughter? They don't know the difference. So just one quick example of how your contract is going to work. Your liability release is not only going to list the inherent risks of equine activities, it's going to give examples. Bucking, rearing, spinning, biting, kicking. All of these are a horse's reaction to unfamiliar sight, sounds, and voices. So when the injured person tries to sue you and they say to the judge, well, Judge, I didn't know that the horse could rear if it got scared. Well, Your Honor, actually the liability release that she signed actually has rearing as an example of what this horse might do. That's the case that I want. Who's a participant and who's a spectator? You may have heard this before. Spectators are not participants in equine activities. In some states, a spectator can become a participant if they are someplace they're not allowed to be. I have a case where an individual was bitten on the chest, and he was walking through the barns in the backside called a racetrack, and he claimed that I was just a spectator. I was where I was allowed to be. Really? Who let you in there? You are not allowed to be in there unless you have a permissible pass. What can you do about that? Who here thinks that riders are more injured in a warm-up ring than the spectators? Who thinks that the person walking into the arena, my daughter has to have her water, is going to pay attention to all the horses running around in the warm-up ring? I find more injuries for trainers and parents on the ground in the warm-up ring than those kids on ponies. What does that mean? That means that at your events, at your barn, you're going to post signs that say, no spectators beyond this point.
What does that mean? That means when they go beyond that point, they are now a participant. Why do you care? Because now they are a participant. Engaged in an equine activity. They can get run over as much as they want because you've got your liability protections. All right? You know I'm only kidding here, but the reality of it is those spectators have to be warned where they are and are not allowed to be so that you have liability protection. Okay, enough of that lecturing. I'm going to skip through this. This is really just what the spectators' responsibilities are. Again, these should be common knowledge, but the reality of it is people will still sue even if they do something wrong on this list. Okay, here's the nuts and bolts of it. You did everything right. Why is Yvonne so busy in litigation? It's because of these exceptions. Now, every state, as I said, is a little bit different with their exceptions, but generally, these are the exceptions you should be aware of. What I'd like to do is use a real case that I had a number of years ago that addressed each one of these exceptions because I think it helps put in perspective what did Christy say for our visual learners, or I have to give an example, otherwise you're guys are going to look at me like deer in the headlights, which I think is some of you are getting close. All right. So 9-year-old girl taking a riding lesson at an up-down facility, lesson program. Everybody's seen them, right? Before, they've got their lesson horses, they've got kids moving in like a revolving door. This particular child had been riding in our program for a year and a half. She was what we would call an advanced beginner. She could walk, she could trot, she could canter, she was jumping 18-inch X's. She had competed in our local schooling shows. So what my trainer had done was in her regular lesson, had provided this rider with a different horse because she was improving in her ability. This horse had to be kicked a little bit less than the other one, we'll say. Now picture this lesson horse. Chestnut, there's your visual. 30 years old, lymphangitis in all 4 legs, wouldn't run if it was being chased, okay? The lion's coming, I'm taking one for the team. This is the perfect lesson horse, and for all of us protecting our animals, I will say there was no abuse of this animal. He was in fine condition to do what he was doing, nothing more. She was jumping these little X's. She would jump the first one at a trot, canter over the second one, canter over the third one, canter over the fourth one, and pull up the horse and talk to the trainer. Okay, can everybody picture this little lesson? She jumped the first jump, she jumped the next 3, she pulled up the horse, she talked to the trainer said, how did that feel? And she said, well, I felt a little uncomfortable. Now, how many of you in this room would have a business if you pulled your rider off every time they said, I felt a little uncomfortable? You're probably more uncomfortable, okay, than watching this person ride. But the trainer's watching, the child was completely in control, the horse was in control, this was a learning exercise. She said, okay, why don't you pick up your trot and let's go through it again. Picks up her trot, jumps the first jump, jumps the next 3, pulls up the horse next to the trainer. Trainer said, how'd that go? She says, I still feel a little uncomfortable. Well, they have now been going for 35 of the 40-minute lesson. So the trainer's famous last words, what did she say? You guys have seen this presentation. Picks up her trot, jumps the first one, jumps the second one, jumps the third one, the fourth one, and I know I'm in a room of quarter horse personnel, but you probably have seen the jumping exercise where the rider gets left behind a little bit and loses her balance, right? Gets a little bit left behind the motion, plops around a little bit, because like I said, this horse is on complete, monotone level, not going any faster, no slower, doing his thing, continues to trot along while she's screaming and throwing her arms and whatnot. She falls to the ground, the horse stops. The saddle's intact, the stirrups are in the proper place, the reins are laid across the horse's neck, the rider is on the ground. She did land on her hip, she fractured her hip bone. I'm happy to say it did not affect the growth plate, she's fine now, but pretty significant injury. The mother sued the barn and the trainer. Now, I'm not leaving anything out for the benefit of my client to say that this was more egregious than it appears. These were the facts. The parents sued for negligence, claiming that the trainer knew that this was not the right horse for this rider, and that was negligence to make her do this one more time. So the lawsuit gets filed, we go into court, I argue the Equine Act, that you are all knowledgeable enough now to say, wait a minute, the sign was posted, she was clearly a participant, engaged in an equine activity, and she was injured as a result of an inherent risk of equine activities, which is what? falling off, right? Gravity sucks. But it's a reality. We will hit the ground. That's what we had to demonstrate to the court. I had a judge and a jury that knew nothing about horses. So here I had to educate both my opposing counsel and the judge about the Equine Activity Liability Act, and I argued those points that I just made to you. And the plaintiff's attorney, who I educated, finally picked up the law book and saw what the Equine Act said, and he says, wait a minute. I know why there's liability here. There's no protections for this defendant, because the tact, remember he spelled it T-A-C-T, that's how good he was. The tact was faulty. Well, I kind of snickered the way he just did and said, wait a minute, what was faulty about the tacking equipment? I had photographs, the saddle was intact, everything was where it was supposed to be, and he says, Your Honor, the tack was faulty because her foot came out of the stirrups. That was my reaction. And I almost got held in contempt by the judge. And I said, Your Honor, have you ever seen the old westerns where the foot gets stuck in the stirrup and the bad guy's getting dragged through the old town past the saloon off into the sunset? That's because the foot did not come out of the stirrup. The feet are supposed to come out of the stirrup. The stirrups are not there to keep the foot in, blah, 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 the whole story. $36,000 later in motion practice, the judge finally agreed there was nothing faulty about the tack or equipment that caused this injury. By the way, that's something I should point out about these exceptions. It's not that the situation existed, it's that that's what caused the accident or the injury. Okay, so no faulty tack. Your Honor, says plaintiff's counsel, I know why they don't have liability protections here. This was a mismatch of that horse and rider. Christy had pointed out earlier to make sure you have the right horse with the right rider regardless of what the rider tells you. But we have seen this rider for a year and a half. She already rode for 35 minutes. This horse wouldn't run if it was being chased. Where is the mismatch of this horse and rider? Your Honor, this clearly was not the right horse for this rider. Why? Because she fell off. You didn't laugh. I laughed and got in trouble again. So I had to go home and produce the thrills and spills of 3-day eventing. That was fun for me. My Olympic team falling off of their horses in international competition. I had to demonstrate that the best in our sport will fall off of their horses. Again, gravity is everywhere. The art of riding is keeping the horse between you and the ground. It doesn't always work. So, again, another $40,000 in litigation expenses, convincing the judge that this was not a mismatch of horse and rider. They were actually appropriately matched. The judge threw out that exception. All right, Judge, I got it now, says the plaintiff's attorney. The reason this rider fell off was the result of a dangerous latent condition of the property. Now, dangerous latent condition is your hole in the ground, right? You know there's a hole in the middle of the arena. While it might be fun to watch your opponent fall in the hole, we really can't allow that to happen with our knowledge. If you've got something in your arena that you know is dangerous, a board sticking out, a nail sticking out, you must fix it. That's acting reasonably. Well, not only did I not laugh, I was significantly puzzled. I was curious. I could not come up with what was the dangerous latent condition of the property. Let me show you. 18-inch X. You can picture it in the arena. She had already jumped it how many times, right? How was I going to demonstrate to this judge? I brought the frickin' thing to the courthouse. And I set up this jump, this 18-inch X, and probably not in such good judgment in my high heels, decided that I was going to present to the judge this dangerous latent condition of the property by walking back and forth over the X to demonstrate this was not only dangerous, it was not only not latent, meaning it was open and obvious, but you already jumped the damn thing how many number of times? Okay, a dangerous latent condition is something that's not supposed to be there. It's something that was not intended to be part of the exercise. Unlike here, where that's exactly what the fence was there for. So that one cost a little bit more time and energy to prove, but $56,000 later, and breaking my back, bringing this jump to the courthouse. I left it there, by the way. The judge threw out the dangerous latent condition exception. But it gives you a flavor of where these cases come from. Somebody gets hurt, These are the creative arguments that the opposing counsel are going to make. They have to, because they have to prove these exceptions are the cause of the injury. The last one I'm going to talk about, because I'm not going to really address intentional act. Don't put up spring guns, tripwires. They're not illegal. Don't intentionally hurt somebody. The willful and wanton exception is really that catch-all. It's the one that you're going to see used most frequently, because it's basically saying that you had a willful and wanton disregard for the safety of the rider. That's a subjective test. Now, you and I sitting in this room would say there is no way that that trainer willfully or wantonly put that child in harm's way. But if you're the plaintiff's attorney and you're the mother of this poor 9-year-old who's 70 pounds soaking wet, was on this monster of a horse who wanted to do nothing but kill her, willful and wanton is the argument that's going to go to the jury. And you're going to have 12 jurors who are not like yourself. They are not your peers. They may have never even touched a dog in their life in downtown Chicago. If it was a pit bull and almost killed them. So my point is that trying to convince 12 people who don't understand horses that what the trainer did was actually not only reasonable but appropriate is where the case gets difficult. Now, for your own education, if you want to know, that case, they had claimed $300,000 in medical bills plus pain and suffering. Because it was going to go to the jury, neither side knew what the outcome was going to be. Juries are inherently unpredictable, like horses. So we ended up settling the case 11 o'clock at night before the jury was already been selected, but before the case went to the jury for $25,000. Now I'm going to tell you from an insurance company's perspective, that was a win. That was avoiding the risk of an unpredictable jury. And that was a loss for the plaintiff, because remember, that attorney is taking a third. So I just want to point out that just because it's settled didn't make it a loser, but I want you to know how these exceptions are going to play a role in any situation that you look at. So now somebody falls off a horse at your place, you're going to say, wait a minute. Okay, participant, engaged in equine activity. They assume the risk, properly matched horse. I had my warning sign posted. You're going to think of it differently, and I think that's just going to make you a better professional. Because I don't want you walking out of here thinking, I don't have any liability. I can do whatever I want. There's an Equine Act and I posted my sign. I want you to use liability releases to further protect you. You're going to post your warning signs again because the law requires it in a clearly visible location where the equine activity is taking place, using the exact language from the statute. Can you give me a 10-minute warning? That would be great, Patty. Thank you. The warning signs. I know black and white is beautiful, but if you decide you want to make the sign match your facility, I'm not saying don't do it. What I'm saying is make sure that sign complies with the statute. Illinois requires 1-inch black letters. Don't play games with green letters. Don't make them smaller in size. Okay, and I'm just saying that because it's not the lawyer's fault that I'm telling you to do this. It's what the statute requires. Okay. I want to get to contracts, because this to me is the most important takeaway from today. And I'm not kidding about the free consultation. When this is over, the advantage you all have for being here, and my thank you for being here, call me, email me the contracts you are currently using. You are not on the clock. I'm going to look at those contracts and I'm going to tell you whether they comply with your state. Whatever state you're in, I have every state statute in my office. I will read the statute. I will tell you if your contract is in compliance. If you don't have a contract, free consultation, you're going to call me. We're going to talk about what you're doing at your facility. What risks are you exposed to? Do you have children? Do you have loose dogs? Do you have wildlife? Do you not wear helmets? That was intentional. If those are the kinds of risk exposure you have, we're going to draft a liability release that matches what you're doing with horses and what risks you're exposed to. The contract that you have is going to not only comply with your state statute, but if you are going to other states, if you're crossing state lines as a professional, the way we draft your liability release, it's going to work anywhere you go. You don't have to make it compliant with every state, and I can explain that to you on a one-on-one basis, but I just want you to know that I don't care where you are or where you're going. Take those pieces of paper with you on a clipboard, in a folder, put it under your hat, I don't care. Take them with you and use them. Not only are you going to have the inherent risks in there, but now based on the exceptions, we can actually broaden the protections that you can have that are not provided by the statute. And here's how we're going to do it. Please don't use a form liability release. Why? It's not written for your state. It wasn't written for what you're doing with horses. It wasn't written in a way that can increase your liability protections like I'm going to do for you. Let me give you some examples. Every state has what's called a statute of limitations. That's how much time somebody can sue you. In most states for personal injury, it's 2 years. Wisconsin, it's 3 years. We can put in your contract that if somebody's going to sue you, they have 1 year to do that. Now, don't ask me to make it 1 minute because I can't do that. But I have found enforceable reducing that time they can sue to 1 year. Why do you care? Because when somebody gets hurt, they're going to call a lawyer, and the lawyer's going to say, well, when were you injured? And they're going to give them the date. They're going to say, okay, well, there's a 2-year statute of limitations in that state, so we're still good. A year and a half later, they're going to file that lawsuit. And the first motion that I'm going to file is a motion to dismiss that case because they blew the statute of limitations. Why? Because your contract gave them 1 year to sue. And by the way, if nobody signs it, it doesn't work. Get them signed. Okay, limiting your exposure by amount. We can't limit personal injury, but what can we do? We can limit property damage. As I said earlier, horses are property. If you have a client who signed a liability release, which is going to include releasing you for liability to the injury of their horse, no offense to anybody in this room who values horses, but I'm going to tell you, the horse that they bought for $3,000, all of a sudden is worth $30,000 when it gets hurt. All of a sudden, that whatever plastic material saddle that they're riding in, all of a sudden it was a Billy Cook with all kinds of bling on it, with Swarovski crystals and everything. So all of a sudden their damages are going to be exponentially higher, and I wish I could say I was making up these examples, but that's really what happens in litigation. And so when I had a case where the client was claiming $180,000 in lost personal property when she got kicked out of the barn, and we kicked her out of the barn and she left all this stuff behind and it got stolen. No offense to trail riders, but she was a trail rider, and I'm talking about your weekend trail rider, who all of a sudden had a dressage top hat and tails and a dressage whip with crystals on it and a Billy Cook saddle. You name it, she had it. And how did she prove it? She pulled the catalog, the Dover Saddlery catalog. All of a sudden, she had something that you found on these 1,500 pages. We really had a hard time disproving it before trial. But the point was I brought a motion to dismiss the case for the $180,000 in damages, claiming that she can only sue for $500. Why? Because the liability release that she signed and the boarding agreement said that the highest exposure we could have is $500. The judge threw the case out. He didn't even send it back to municipal court, which is your $500. He just threw the whole thing out. Choice of jurisdiction and venue. This is how your contracts can go with you. Your contract is going to say what state law applies. So if I draft your contract under Florida law, because that's where you're located, and you end up teaching in Georgia, the person that's going to sue you, they're not only going to have to apply to Florida law, they have to sue you in Florida. Well, who's really going to want to go outside of their comfort level, hire a lawyer in a state that they don't know, and have to ask their witnesses to travel to another state? It's another form of deterrent for you to have in your contract that the state's not going to provide, and a form contract is not going to give to you. You're going to have assumption of risks in there. We talked about what the rider assumed. Here's another takeaway. I don't care who tells you minors can sign a contract. They cannot. I don't care what state you're in, or what country for that matter. Children under the age of 18 cannot sign a contract. They can sign it, but it's not going to have any legal enforceability. So what do my contracts do? My signature line has the parent signing on their own behalf and on behalf of the minor child. Why does this matter? One, that means that you need one liability release. My liability releases are 1 page. Now, only I can do small print. You can't do it. And it's one-sided. Why? Because I've had litigation where the page 2 of 3 was missing, right? And that happened to have the liability release language on it. Or they didn't see the back side. Or the warning language that's required wasn't on the page that I signed. So the liability release and I have the warning language is right above that signature. It's not on page 2. They cannot say it wasn't on their contract. But that signature line not only has the parent signing for the child, but on their own behalf. Because guess what happens when moms bring their kids to their riding lesson and the horse gets loose and runs out the gate? Guess who gets hurt? Mom gets hurt. And guess who's going to say they didn't sign a liability? I didn't sign. I signed for my kid. I didn't sign for myself. So your one-page liability release will work for anybody riding, any parent, and any parent signing on behalf of their minor child. One piece of paper covers all three of those situations. And by the way, somebody comes as a spectator to watch a clinic, they sign the same release. The participant is defined as participant, spectator, invitee, guest. We can use any word you want. We can call them a jamoke. Whatever word you want, they are signing as a participant under your liability release. What else can we do? We've got our liability releases in place, but guess what? That piece of paper is not going to pay your legal bills. The insurance companies will defend you if your claim is brought under an insured policy. I don't want you paying my bills. I want your insurance company to pay bills. Now, I represent insurance companies, so I can say this. They are in the business of denying claims, right? So let me be hired by the insurance company to defend you. Why is it important to know what your policy says? Because you could spend a lot of money on insurance, but it's got to be the right insurance. Here's my quick example. This is the thoroughbred industry. I had a thoroughbred client who was in the breeding industry. Very, very successful and high-profile breeder. They had a really nice filly hit the ground. They trained the filly, they raced the filly. Who lives with Murphy? Murphy's Law? Okay. What happened? Filly left the gate, rotationally flipped, landed on the jockey, paralyzed head to toe. Very, very catastrophic injury. Claim was tendered to the insurance company. The insurance company denied the claim. Why? Because they had a breeder's policy. They did not have a racing policy. That's like a Chevette versus a Corvette policy. The risks are significantly different for an insurance company and a breeding program than a racing program. So the premiums that were being paid were for a breeding program risk, not racing. Don't lose the farm because you purchased the wrong type of insurance. Also understand what your exclusions are. If you are relying on homeowners insurance and you're running a business, I guarantee you your homeowners policy has a business pursuits exception. What do insurance companies do? They deny claims. So what are they going to say? Well, when your neighbor comes over to clean stalls in your backyard, you are now operating a business. And by the way, you have a business pursuits exception, no coverage. So make sure you know what's covered and what's not covered. How do you do this? You call your insurance agent and you say, I have 2 horses on my property. Am I insured? And they say, oh yeah, you got domestic animal coverage. I don't see horses on that list. Well, it's domestic animals, you know, dogs, cats. I don't see horses. I will tell you, horses are not treated as domestic animals by all policies. And if they are, do they cover you for 2 horses? I had a claim where a horse was injured on a client's property, and the insurance company said, we only insure 1 horse. And they said, well, this was only 1 horse. And they said, no, we insure the other horse. Really? So, my point is, make sure you know what's covered and what's not covered by talking to an educated insurance agent who deals in equines, not just agriculture, not just homeowners, not just your fender bender auto policies. Real quick also, the last part of protecting yourself is if you're going to consider doing business under the name of an LLC, not in your own name. The point of bringing this up under the insurance heading is that if you're going to create an LLC or if you're currently using one, make sure your insurance covers you and the LLC. Because what will the insurance company do? They're going to say, well, your business was sued. This is your personal lines policy. Or the opposite, they're going to say, well, we insured you, but we didn't insure this LLC, and it's the LLC that's being sued. Don't play semantic games with the insurance company. Get everybody insured. If you have a professional coming onto your property, they must show you a certificate of insurance adding you as an additional insured to their policy. My point is the verbal promises go nowhere when it comes to insurance. You have to see it in writing that you're insured for the activities that you are conducting on your property or elsewhere. I am a lawyer who stands by their words. Unlike the government, I'm here to help, for real. If you have any questions about your insurance, about your contracts, about boarding contracts, training agreements, trailering agreements, liability releases, maybe something I've never heard of, call me, email me, ask me afterwards. There is no charge for this phase of the consultation, not because I make money, but because I'm protecting my industry, the horse industry. That's why I do this. I don't charge for my time here. I don't charge for my time to do consultations with you because I want to encourage the industry to protect itself so we can keep doing this for the here and after. Thank you so much for your time.
Okay, we're going to take a 10-minute break and we'll be back. So let's try to, if you're going to move out, get a drink or something, let's try to hurry back as quick as we can.